Now, we're primarily concerned today with why you resigned from SARS. You have given some notes to the Commission. The Commission will study them. And because of the seniority of your position, there are other topics that this Commission must cover in terms of its terms of reference that are not brought sharply into focus today. And if necessary, we'll call you back. But today we're looking at why you resigned from SARS. And as we understand, there are two main narratives, certainly in the public arena, about your resignation. The one is the debacle around your early retirement, and the other is about the rogue unit, the so-called rogue unit. And we know that you were prosecuted for both of those issues. If you don't mind, I'd like to look at them separately, even though chronologically they intersect with each other. It'll be simpler for us to look at them one by one. If we can start with the question of your early retirement. We heard from Minister Gordhan on Tuesday that you had approached then Commissioner Magashula to take early retirement for personal reasons. You had asked Mr. Symington, who was a senior legal person within SARS, to furnish you with an opinion as to whether it would be lawful for you to take early retirement and on certain terms. He came back to you and said it would be lawful. Is that correct?
That's correct.
Mr. Magashula then put in the request to Minister Gordhan, who was then the Minister of Finance. And we went through an affidavit that his assistant at that stage submitted, which went through various steps that he took in order to check whether it was lawful to do what he had to do. And for those who were not here that day, he got an opinion from a legal advisor within National Treasury. He discussed the matter with either the minister or a senior official at the Department of Public Service and Administration. And he also took up the matter with the SARS Remuneration Committee, the chairperson. And after having been told by all those people that it was lawful to grant your request, he did so. And he affirmed that that was correct. You were then in February 2011 concluded your first contract, and then another one in September 2014.
Ms. Stone, so can I just clarify?
Yeah.
I thought that affidavit said there was also an outsider opinion. Or am I wrong? From a firm of attorneys outside.
That came later. You were wrong, yes.
That came later.
That came later, yes. Your second contract, as I have it, began in March 2014, and in September 2014, Mr. Moyane was appointed as the commissioner. I'm also in possession of an opinion that was commissioned by SARS, somebody in SARS, possibly Mr. Moyane, but I'm not sure, to a firm of attorneys, Mashiani, Mudli and Munama. And in that opinion, the attorneys say SARS have asked them to give an opinion as to whether the granting of your early retirement was lawful. And that attorney came back, and in terms of the opinion that we have, he said yes, indeed. As far as they're concerned, it was entirely lawful.
Can I ask a question?
I'm supposed to be asking the questions.
But ask her one anyway.
Was that opinion provided to the Hawks? Was that opinion provided to the NPA?
Well, carry on, Ms. Steinberg. It's a question I would like to ask as well. But I'll ask it a bit, another thing that bothers me, so I'll come back to that.
It's certainly an issue we flagged, and we'll come back to it. Notwithstanding that opinion, you, along with another 3 people, were suspended in December 2014. And the KPMG report was also commissioned at that time. Can you tell us what happened with that suspension?
I had commissioned this Sakonnet panel to produce a report.
You in your capacity as acting commissioner.
Tom Moyane became commissioner, and he then interacted with the Sakonnet panel.
Mr. Pillay, I think take a step back and tell us why you commissioned the Sakonnet panel and what you asked them to do.
We had a previous panel called the Kanyana panel to go into allegations that Ms. Belinda Walters made against Johan van Lokeren. That report did not make any specific findings against Johan van Lokeren, but it left certain things open. And we wanted to settle that once and for all, which is why we asked, we first sought to get a retired judge to do this, but we waited for weeks and we couldn't get the approval. So we then, after informing the minister, went ahead and we appointed Advocate Sakonnet. The Sakonnet report came out. I was not the acting commissioner. It went to Tom Moyane. After 2 weeks, Tom Moyane gave me the report. It took 2 weeks. He kept saying, it's your report, you must get it, but it took 2 weeks. We got the report and we were very surprised. We then set about reviewing the report ourselves. And we produced a document called the Critique of the Sakonnet Report. I hope you have been given that document. Okay. I sent this document to Tom Moyane with a covering note, raising very serious issues. And basically we said it erred in fact and in law. And I asked him to be very careful about this report. Because the way it is, it opens the door to all sorts of things. I mean, right now, yesterday, there's a taxpayer who's been evading his liabilities now for something like 10 years, who's gone to court to say he was investigated by the rogue unit, and therefore the whole process is tainted. Okay, it's not true. It's not true at all, but all sorts of people are going to try these things because of the report and because of the manner in which the report was handled. So I sent this to Tom. I asked him for permission to distribute the report to EXCO members. By the way, by then there were no more EXCO members, but the former EXCO members. And his reply to me was that I received it, I will not read your report, and you cannot circulate your report to the others.
Did he say why he took that view?
Well, I'll read it for you.
Maybe just as you do so, when he makes reference to your report, is it the critique of the Sakonnet report?
Correct, yes. Yeah, he says, I acknowledge receipt of your envelope with 2 sets of documents. I have not read the 34-page document. That's the critique. I cannot approve your request to circulate the report to chief officers. At this stage, I do not consider it appropriate that you share your views with the chief officers, as this could be construed as an attempt to influence or impose your views on them. And if I'm remembering correctly, I was then suspended the next day, together with Mr. Pete Richer.
Sorry, together with?
Together with Mr. Pete Richer.
And you then launched an urgent application at court to overturn that suspension that December, and you succeeded.
Yes, we succeeded, and it was a notable judgment which everybody has ignored. KPMG has ignored, SARS has ignored, because it says, you know, technically speaking, the unit in question was approved by the minister. It says that the Sakonnet report doesn't have any findings against me, and it ordered that the suspension be withdrawn, which it was, and then it was reimposed a day or 2 later.
So you were suspended afresh,
Yes.
a day or 2 later. We've strayed into the rogue unit narrative. I don't think there's much left to say about the early retirement narrative. As I understand,
May I say something on that? You were then prosecuted, as I understand it, together with Mr. Godin and Mr.
Magashula.
in relation to this pension issue. Is that right?
That's right.
When did that prosecution start? When were you served with an indictment?
I was served with a summons. Let me find it.
This one, 10 October.
My information is that it was on the 11th of October 2016.
Yes,
that about right? I don't
Yes.
need the exact date.
Yeah.
Now, that prosecution was instituted and was later withdrawn.
That's right.
Now, I'm a bit puzzled, and it goes back to this opinion to some degree. I'm a bit puzzled as to why there was a prosecution when there was legal opinion inside and outside the institution that everything had been legal. And so, just bear with me for a minute. I've actually been in touch with the Director of Public Prosecutions, Mr. Abrams. You know, normally when there's a prosecution, there's first some evidence put before the prosecuting authority, usually in the form of an affidavit, setting the basis, and the prosecuting unit will then decide whether there's a case to me. And I've asked him, was there any information placed before the prosecutors before that prosecution started? I'm not quite sure what the answer is at the moment, but he said that he'll send me all the documents. Do you know whether there had been a complaint laid, in other words, an affidavit of any kind, to found that prosecution in the first place? If you don't know, that's fine. We'll see it in the docket that will be provided soon, but I just wanted to know if you know.
There was a complaint made in a few days after my settlement agreement, when we separated.
That was much later, so that complaint could not have triggered an earlier event, which was laying charges against you in October 2016.
No, the complaint was laid in 15th May 2015.
I see.
Yes. So a few days after, there's a separation agreement that says all investigations are off. A few days after that, Mr. Moyane lays a criminal complaint on the 15th of May.
Is this now about the pension issue?
Well, it's a broad complaint.
I just want to know, do you know offhand? If you don't know, if you're doubtful at all, I'm getting the documents, it'll be there, but I just want to query, do you know whether the complaint related to the pension issue at all? Because there's been a second prosecution against it. Do you know whether that complaint at that time put before the prosecutors was related to the pension issue, or don't you know?
Can I just check?
No? No, sorry. If you don't know, just tell me you don't know at the moment. I'm getting the documents, we'll look at it. And I think that your answer, I understand, you said you're not sure at the moment.
I'm not sure.
And the prosecution was then withdrawn. Do you remember the date when it was withdrawn? I suspect I have it here somewhere. But
It's the 31st of October 2016. Does that sound right, Mr. Pillay?
no. Yes. Sorry, 31st of October 2016.
Yes. Well, 30th of October 2016.
Yes. And were you ever told why it was withdrawn after it had been started in the first place?
I'm not sure whether we were told officially, but I mean, they released a statement to say that the NPA was now aware of the opinion made by Mr. Symington. Yes.
But that opinion had been given long before the prosecution started.
Well, there's a communication between the NDPP and the then head of Hawks in Tlemeza, where the NDPP accuses Tlemeza of suppressing the document or not passing on the document to the NDPP.
Well, I'm told as well that the present acting commissioner got knowledge of that opinion only, where is it?
The attorney's opinion.
Yes. No, just show me the date.
On 18 April.
The present acting commissioner apparently says the first time he got sight of that opinion was in April of this year. So I just wonder, I mean, this opinion has been in SARS all this time, and the acting commissioner has only first time seen this.
Well, Judge, my assumption would be that that opinion would have been in my personal file, which file, by the way, for some time was in Mr. Moyana's office in his safe.
But one might expect, though, that if you're going to start this prosecution, that this information would have been given to the prosecutors when they were asked to prosecute. Do you know why they did not have it?
I can only assume that it's suppression of evidence.
Can I just add one thing here? Mr. Pillay, my recollection from press reports is that the three of you, former Minister Gordon, Mr. Magashula and yourself, were invited a few times to give evidence, to make representations. You were called in to the Hawks and that. Did you give them that opinion of Mr. Symington while making your representations?
Well, what happened is they called me for what they call a warning statement. They actually didn't ask us any questions, and at that stage, they hadn't formulated the indictment. They didn't ask us any questions. They took us through and explained what they have. We asked for time to make representations to the Hawks. And as we were pursuing that, the Hawks then said, listen, the time has passed. We are now sending it to the NDPP. That's the end of the matter. And that, we have correspondence on that.
Let me just make sure that we get this clear. There are two opinions we're talking about.
Yes.
Right at the outset, when you were contemplating this pension arrangement, you spoke to Mr. Symington, and he gave an opinion. Now, that's in 2009. Okay. There is another opinion on the 5th of November 2014. Now, that is after Mr. Moyani has become the commissioner. That opinion is from the outside attorneys. And that opinion was no doubt then asked for by Mr. Moyani, presumably. Well, and he gets, that opinion is dated November 2014. Now, that opinion has only recently come to light here, apparently, because Mr. Kingan, the present acting commissioner, saw it for the first time in April of this year. Do you know where that opinion has been from November until now? You say it ought to be on your file.
No, well, the 2009...
Leave that one.
Yeah.
Let's deal with the outsider one.
I wouldn't know at all, because by then I was probably on my way out.
Yes.
Again, I can only assume that it's a suppression of evidence.
Well, we'll look at the file that comes from the Director of Public Prosecution, and we'll see what is on that file.
Just for clarity, for myself, Mr. Pillay, you left the employ of SARS, well, at least, you left the employ of SARS, is it on the 5th of December?
No, I was suspended on the 5th of December.
Suspended 5th of December 2014.
Yes. Yes.
So that's about a month before that, a month after the opinion had been received. But you had never heard of the opinion?
No.
And the other piece of the puzzle here that we have left out that I think should also be on the record is that there was a very well publicised event in which the Hawks had asked Mr. Symington for an affidavit, and they had given him certain documents, and he ended up being detained in a boardroom here at SARS because he didn't want to give up the documents that he'd been given. We now have a copy of the document that caused all the trouble. And that document was an email from the same external attorneys who'd written the opinion saying your early retirement was lawful, saying to the commissioner that they don't want to be involved in an investigation and prosecution of you because it would be, quote, unethical, presumably based on the fact that they had already furnished an opinion that said what you had done was lawful.
Yes.
And now Mr. Symington faced charges and has gone through his own story as a result of that incident. I believe there's still a disciplinary inquiry pending in that regard.
There is if I may comment, there's a pattern of behavior here that they determine that somebody is to be removed or kicked out of the organization, and then they go after them, and then they hire professionals, most times, who are prepared to do these things. And they don't let anything get in their way. So it's a sad thing. I think we've seen that with the previous persons who have sat here before me. They just let nothing get in the way of what they want to do.
Well, if I may say so, I think that that's one of the things that we're looking into. I think we just need the facts, and we will decide whether that has in fact been happening or not, if you don't mind, Mr. Pillay.
Can we move away from
No,
that?
thank you. I just wanted to clarify the sequence of events in relation to that prosecution for the pension issue. Thank you.
Mr. Pillay, the other narrative is the rogue unit narrative. Now, we're aware that you are still facing prosecution. There are criminal charges against you, and that's not yet finalized. We don't in any way want to interfere with that case, and we will do our best not to trespass on that domain. If you feel that any question might be compromising in that regard, please tell us, because that's the last thing this Commission wants to do. Can we start at the beginning? There is so much noise around this rogue unit. We heard this morning that it was a lawful unit set up in SARS some years ago. And perhaps you have a little more detail and insight into the origins of this unit, how it was established, its legality or otherwise, and a little bit about what it did.
Yes. The early discussions about setting up a unit took place between Mr. Pete Richer and leaders of the National Intelligence Agency.
Mr. Richer was a SARS employee at that point.
We had for some years, as we worked on the field, we began to notice how big a problem the illicit economy was becoming. We had sent a number of requests to the intelligence agencies for assistance. We didn't really get any assistance. which is why we developed the view that let us try and set up this unit within the National Intelligence Agency. We'd be involved in the recruitment and the training, but they would operate in the agency. They would be dedicated. Now, there's a precedent for this. And as Mr. Gordon said on Monday, we created such a capability in the NPA, in the prosecutions. After they took our delegations away, we then spoke to them to say, look, this is what we want to do. And we got the initial funding for the unit, and the unit had at one time up to about 25 prosecutors dedicated to SARS matters. So there's a precedent. That's how we were thinking about the problem. Essentially, dealing with the illicit economy, you're dealing with organized criminals. And your normal SARS person, your normal SARS auditor or customs officer, A, will not have the capabilities, but B, may not want to be involved in investigating organized crime. So at some point, the negotiations between Mr. Richer and National Intelligence stalled. And it stalled from their side, from National Intelligence. In the meantime, we had been setting up things. We had prepared the pipeline. And we said, okay, let's continue. We'll try and sort these things out as we talk to National Intelligence. But ultimately, we failed. We then tried with SAP's crime intelligence. We also failed there. So we then continued to set up the unit, because by the time we reached the point where it was clear that Nia was not going to come to the party, we had already started recruiting people. And that's part of the pressures of when you ask for a budget and you've got it, and you've got to spend it, otherwise you lose it. And so that is how it comes about. It's also part of the general approach, and you might have noticed some of it from the slides that Mr. Gordon showed. We tried a lot of things at different times. And we did, and we learned, and we changed, and we went on in that way. After about 18 months, we reviewed where we were, and we made huge improvements to the group. We tried to get the policies in place, we get the procedures in place, get the proper training for people, get the management streamlined. And over the years, it began to change again, until in the last few years, it was down to a unit of 7 or 8 people. as we migrated people to the different units. Some left SARS and so on. The work that it's done, the reports are available. They did some fantastic work on the tobacco industry, on abalone, on 2 or 3 huge drug busts. And they worked quite closely with the other members of intelligence services. There is, I think Mr. Ravelli talked about discussions between the SSA and ourselves. Around 2010, when some of the rumors had started to gain traction, and the minutes of those meetings are available as to what we discussed. The meeting that Mr. Ravelli talks about, I was present at. And after the meeting, there was a continuation. We provided them with documents. We provided them with the names of
Sorry, you provided who?
the SSA,
The SSA.
with the names of the people. And in fact, I was in a meeting with Mr. Ravelli when we had a discussion after some time with the SSA to say, what's your finding? Give us a report. Well, the gentleman said, listen, there's no problem, but we won't give you a report. Okay.
I just need some clarity questions before you move ahead, Mr. Pillay. The NIA, the then NIA, and the SABS crime intelligence never came to the party when you were seeking that there be cooperation around this. Did they ever set out to you why they were not cooperating on this?
Look, I think we must ask Mr. Richard that, who was involved in those discussions. But I can only assume that they were uneasy with having a dedicated unit in their own midst that would be also answerable to us. That would be my assumption.
But didn't they ever write to you and set out the difficulties they have with the proposal?
No. So let me come to one point, that is, it is true that in setting up the unit, and even later when it came to the much smaller unit that existed, we tried to shield them from the normal SARS officers, but at all times they were employees of SARS. They received salaries and they received tax certificates, etc. They were on medical aid, so they were SARS employees. Are there any specific questions you'd like to put?
I think you've answered the question, certainly from my side, as to the origins of this unit. Are you aware, we've established that the unit itself was lawfully established. Then there's another question. Did it exercise its powers lawfully? Did the people who work inside it do so properly and lawfully, as far as you know?
My answer to that would be that I think overwhelmingly they did the right thing. Is it possible that some things went wrong? I think that's possible. I think that's always possible. But by and large, the unit did some excellent work.
Did you ever receive any complaints about any of the members of that unit having gone rogue? I mean, it may have been lawful, but as it happens in lawful institutions, people do go rogue. Were there ever any allegations about, in relation to any of the members, that related to unlawful conduct?
No formal allegation was put to me.
And the good work you say that they did, are you talking about the work in stopping the illicit industries from operating?
Yes.
Can you tell us just a little bit more about that? What they achieved?
From about, I don't know, 2011, 2012, we made huge inroads in the tobacco industry. By the way, dealing both with the licit and the illicit. I mean, the big players, the very, very big players who are well known to you, they also cut corners. And we closed a number of operations down. And some of it is due to the way they go about their work. I mean, there's one good example would be that unlike your normal auditor, they would be prepared to go and sit outside a gate and see how many trucks go in and out. But they would also be quite innovative. I mean, if they noticed a camera, JPMD camera, then they went to the authorities and said, listen, can you, this is what we're doing, can you refocus the camera? So it's that type of thinking. They did work on Krecha. We did work on the illicit gold dealing, where we made some huge breakthroughs. And they would also do work that a normal audit or a normal financial investigation, they're doing something and they come to a point and they can't proceed any further. They're trying to trace somebody. And we would hand this over for them to look at. My own view, I can't see how you can have an effective revenue authority without such capability.
Minister Gordhan, in fact, spoke about how in other areas of SARS, as you as a team were establishing SARS, you benchmarked best practice. Does this type of unit exist in other parts of the world, in other revenue?
Yes, it does.
Any examples?
Sorry, Ken.
Any examples, any countries or jurisdictions which you know have similar units?
We did the work. I'll prepare the document. I'll send it to you rather than hazarding a guess. But
Mr. Pillay, can you just tell me how many? I presume that the number of people in this unit varied over time. What was the maximum number of people?
26, 27.
26. Well, all I can, it troubles me a bit, let me tell you. There are 14,000 people in SARS. And reports leaked to a newspaper in one way or another. They may be true, frankly. You say that we've heard your evidence. We may hear other evidence that it's true, that they were. But whatever it is, the alleged activities alleged in a newspaper of 26 at the most people were up to, has affected 14,000 staff members. It's quite an extraordinary thing.
It is. It is.
Sorry.
And was and it was the primary reason that EXCO was disbanded
Yes.
and as a whole.
Yes, and look, it was disbanded because Moyane demanded certain reports. The reports were prepared and given to him. The same reports went to the Sunday Times, and the Sunday Times published it. And then he acted.
Now, there have been panels and investigations into the rogue unit. You mentioned the first one, May 2014, was the Kanyane panel, and that was quite specific.
Very specific.
That was Ms. Belinda Walter had laid a complaint about Mr. van Lochenberg. You then said the outcome wasn't clear enough, so you, in your capacity as acting commissioner, commissioned the Sakonnet panel. What did you ask the Sakonnet panel to do?
Basically, we asked them to investigate the allegations that Belinda Walters had made about Johan van Lochenberg. It wasn't an investigation into a rogue unit, but she made certain allegations that Johan had intercepted her communications and so on.
Now, after the Sakonnet panel had started its work, but before it had completed its work, Mr. Moyane took office.
That's right.
And you made a representation to the Sakonnet panel, which you gave to Mr. Moyane. Is that correct?
Yes, I did.
Then the terms of reference of the Sakonnet Commission changed. Is that right?
That's right.
Can you tell us about that?
Well, the first I knew about it is when you actually read the Sakonnet report. That's where they say they decided to change the terms of reference.
They, the panel, or on instruction?
What it says there is they, the panel, decided to change the terms of reference. They could not ignore the publication of articles week after week by the Sunday Times. That's basically it.
And did they broaden the terms of reference?
Yes.
So it became wider than the complaint laid by the initial complaint to include what?
To include the allegation, the so-called allegations about the rogue unit.
Now, you'd already made your submissions to the panel. Were you given an opportunity to make submissions to the wider terms of reference?
No. I met the Sakonnet panel twice. I met on the first day. And I gave them a briefing. We then submitted a written report, first written report to them. And we then had a meeting with them. They did not inform me that they had changed the terms of reference. They asked questions about equipment and about a 600 million slush fund, as if you can hide 600 million so easily. And we then went back to prepare a second submission to the specific questions, which we got signed off by the CFO to show expenditure, to say, I've been through all the documents, and there's nothing like that. We submitted the second one.
Was the CFO at the time?
Mr. Bob Head. And then finally is, after the report is out, we read the report, we prepare a critique, which we give to Moyane.
I see. And that's the critique that Mr. Moyane said he wasn't going to read and he wasn't going to let you circulate. The Sakonnet report comes out on the 5th of December. You get it a couple of weeks later.
Yeah.
Now, you said earlier that was one of the reasons why you were suspended. Now, what are the findings in the Sakonnet report that underpinned your suspension?
Well, you can search for it, you won't find it.
The report doesn't make adverse findings against you.
In fact, there is a media quote the day after our suspension from the attorney who served Sakonnet, who says that the report does not mention Mr. Richer or Mr. Pillay.
Well, we have a copy of the papers in the Labour Court.
Yes.
And there it would appear what's underpinning your suspension is your involvement in the rogue unit. But that was not what the Sakonnet panel found. So you won that urgent interim interdict, and the day after you were suspended again. What then happened?
Well, there are attempts to try and resolve the matter. And that's happening in parallel with me getting legal advice and preparing for this action that SARS is taking. There are 3 attempts to resolve matters. The first attempt starts with a meeting between Moyane and myself at the Pretoria Central Prison. That's the venue he chose. So the first attempt wasn't successful. The second attempt was under the then Deputy President, who is now the President. And that did not succeed either. Somewhere in the process, I also get a letter from SARS lawyers making a demand for 110 million rands, because that's the cost of the rogue unit.
The cost of the equipment?
No, I think it's the cost of setting up the unit and salaries for a year or something. I'm not sure exactly how they calculated that. The third attempt succeeds, and Deputy Minister of Finance, then Mr. Mcebisi Jonas, convened a meeting between Moyane and myself, and we we signed a separation agreement.
When was that?
That's on the 6th of May.
I think we should point out that at that point, the CCMA
Yes,
had found that your first suspension was unlawful.
that's right, yes.
But you had also, in that intervening period, you'd been given charges relating to a disciplinary hearing.
Correct, yes.
So a deal was brokered on the 6th of May. Can you tell us the terms of that deal?
Well, basically, it says that there will be no further investigation. I will resign. I'll get a payment of some months. And the SARS would pay for my and Pete Richards' legal costs if any criminal proceedings ensue from anything arising in the course of our duties. There's a press release dated the 7th of May, and the last sentence says, all SARS-initiated charges and related investigations have been withdrawn. But on the 15th of May, Moyane lays a criminal complaint.
A week later. And that criminal complaint was based on the KPMG report.
Yes, it uses the KPMG report, yes. Yeah.
Now, can you tell us a little bit about that investigation, the KPMG investigation and report?
Well, I can only tell you what we see from the outside. The KPMG has never informed us that we're being investigated. Nothing has ever been put to us. And in fact, when we wrote to them to say we are aware of this and we'd like to engage with you, they basically said, we've been told by SARS not to engage with.
So the report made adverse findings against you without hearing from you?
Yes.
Well, just stop with that. I've read that report in its various iterations. It's a very long report. They say there that they trawled through 1.5 million emails. But did anyone phone you and say, well, what do you have to say about all this?
No, nobody did. And I'm surprised that this 3 million was on paper. In the end, they cut and pasted a SARS report.
Well,
SARS report.
We'll see.
A SARS communication.
Well, you don't know that, do you? Do you know that?
Yeah.
SARS, the recommendations.
The recommendations from the SARS lawyers were cut and pasted into their conclusions.
How do you know that?
It's come through yesterday in the Nsebeza inquiry. And they admitted so a few weeks ago in Parliament also.
What did that report find about you?
Wow.
In a nutshell.
What did it not find? I'm going to quote one or two choice pieces. It says about me and Ronnie Casserols, the previous minister, that they investigated as to whether I had done something to benefit him, his tax affairs. And they said we could not find any evidence. But given all that is said about Ivan Pillay, it may well be that he did something. It's said of Johan van Lockerenberg, we checked to see if he has an offshore account. We couldn't find anything, but it doesn't mean that he doesn't have it. All right. Well, suffice it to say at this stage that the recommendations, the conclusions, the findings have been withdrawn.
That's correct. But the prosecution hasn't been withdrawn, has it?
No, the prosecution has not been withdrawn. We've received the docket, and we are engaging with the prosecutions to get the full docket.
Well, Ms. Steinberg, it might be that the prosecution is based on other information other than in KPMG. So I think that whether the prosecution has been withdrawn or not depends on what the prosecutors have in their possession. They may well have other evidence suggesting wrongdoing. So I think we'll leave that, if we may.
I'll just ask, against whom are the charges in this prosecution?
The latest one is against Andries van Rensburg, Johan van Lochrenberg, and myself.
Just a point of clarity. Let's put aside the undertakings relating to the termination of all investigations against yourself in the 6 May settlement. Were the other undertakings, particularly in respect of meeting any legal course in respect of any matter that would ensue, honored by SARS?
No. No, we've written to SARS, we've written to the Minister of Finance. It's not yet been honored.
Has there been any reason given to yourselves as to why, as to why that's the case, that they've not honored the undertakings?
No, not yet.
Mr. Pillay, you mentioned that the terms of reference for the Sakonnet panel were amended, or they were altered. Was the commissioner as surprised as you were that they were altered, or you wouldn't know?
I don't know.
Was it in their power to amend their terms of reference? I'm just you set it up from the start. You gave the first mandate.
I don't think so. I think if they feel such a thing, they needed to come to the person in authority to say, we think that there should be a change, an amendment. That's what I would assume.
I'm just putting aside assumptions. In the mandate that you gave to the Sakonnet panel, did you give, as part of what they had to do, the power to amend their mandate?
No.
But to be fair to the panel, there was now a new commissioner, and they may or may not have gone back to him, or he may or may not have instructed them to chair. We don't know, and that's something for another day. So you brokered the deal. Part of the deal was that investigations, etc., would cease, your legal bills would be paid. The following week, there were fresh investigations against you, fresh charges laid against you based on the KPMG report and maybe other allegations as well. After that, you laid a complaint against the Sunday Times with the press ombud. Tell us about that.
Yes. The one part I didn't deal with during the suspension, the very difficult thing is that when you're under suspension, you can't make press statements. It's very difficult for you to clarify things. So we'd been under assault from the Sunday Times especially for a very long period. And when a version of the KPMG report was leaked, to the newspapers before we even saw it, we decided that, okay, enough was enough now. we should engage the press ombud, which we did. And they found generally in our favor. They allowed an opinion piece by myself and Johan van Lokrenberg to be published, and they actually seized that campaign. Basically, they ran a campaign for weeks on end. I think that sums it up.
Ran what campaign?
They ran a campaign, well, against Mr. Gordon, Johan, and myself, week after week. 37 different issues of the Sunday Times that had us on, the first page, second page, or something like that. It went on.
Now, the charges in respect of the early retirement have been withdrawn. You are currently facing charges in connection with the rogue unit. Is that where we're up to in real time?
That's where we are.
In your written submission to the Commission, you end your submission with some recommendations for the future, and how you think, particularly the governance model, could be adjusted to stop some of the problems that you've identified in the past. And we'd be grateful to hear your views on that after your years in leadership in this organization.
Thank you. The first recommendation is actually about the appointment of the commissioner itself. And we're recommending a rational, independent, and open process for the appointment of a SARS commissioner. And that such a process should include vetting by an ad hoc parliamentary committee. And such persons should prove that they are fit and proper to hold the position. Now, the SARS position is quite a powerful position, and it rolls up quite different roles all into one. And it's all the more reason why we should be very, very careful.
And at the moment, there's no fit and proper requirement.
And there are many parts of the law where there is discretion. Now, on our own in SARS, we made sure at that time that there was proper policy, procedures, and governance, checks and balance. In fact, it was quite tight. But perhaps there is a need to hardwire this in a way in which an incoming commissioner cannot just change it by his or her whim.
Sorry, can I just ask, Mr. Pillay, there are many provisions in the Tax Administration Act, the Anti-Avoidance, but many that say, in the opinion of the Commissioner. Are you suggesting all of those needs this process?
Yes, we have to find a way of I think hardwiring some of them, and that they must at least be reported on.
But take on the GAR,
Yes.
where the Commissioner contends that there was a tax avoidance scheme. If the taxpayer disputes that, it goes to court.
Yes.
Is that one of the ones that should go through this process?
No, well, that particular one, because it goes into the court, because it's a public process. So that's, I think that particular one, I think that's fine. But where discretion is applied.
Penalties for late payments?
Yeah, things like
this procedure?
Yeah. It might even be decided that we do it, but you do it if there's a threshold of X million rands. But below that, you do it in a different way. But whatever it is, there's a need to look more closely into it. And then there's other than tax investigation, the sort of so-called anti-corruption investigations, or the sort of KPMG thing, the endless investigations. And we are suggesting here that whenever something like this is done, we should also be special measures to ensure that there's proper governance over this. It's not only in SARS, in many other institutions. The professionals are hired to be hit persons. Then the issue of the accountability of the commissioner. I think we all noted that there was an issue about the president's authority and the minister's authority with respect to the commissioner. And that needs to be clarified. Surely the president cannot be responsible for the normal management of the commissioner. Then...
Sorry, may I interrupt you? Well, where should the ultimate power lie, as it were, with the minister or with the commissioner?
I think the commissioner must have sufficient powers so that the autonomy is maintained. But there must be an accountability and a reporting to the minister regularly. Now, although there was even this lack of clarity in the previous period, but the practice was that every 2 weeks, the EXCO met Minister Trevor Manuel, and like clockwork, it worked. We wrote reports. We were accountable. We felt accountable. We unfortunately now have to do a situation where you've got to make the people accountable now.
Just clarify for me, though, because I find it quite an important question. You're saying that you see, what you're talking about is, it's in the Constitution, there should be cooperative government. In other words, government institutions should be working towards the same goal. So you'd expect there to be an interrelationship between them. But where would the ultimate decision-making lie? With the commissioner or with the finance minister?
Not over operational issues. The minister should not have final decision-making over operational issues.
The commissioner should have that, but in engaging in some way with the Treasury.
Yeah. And then if I may move on to the next item, then in combating the illicit economy, perhaps there's an opportunity now once and for all to clarify how an institution like SARS will work on the illicit economy. What capability should it have? And then, in line with FICA rules, SARS should create a dedicated capacity for the politically exposed persons. Persons so defined must be informed of the fact and alerted to additional scrutiny of their tax affairs. And then
Sorry, before you move on, could I just ask, in terms of the existing administration, codes here, law, is it adequate to deal with politically exposed persons? Are there any current deficiencies?
It's not required of SARS to deal with politically exposed persons in the way, for example, the FIC would. It's not a requirement. We have in SARS a VIP unit, or they call it a restricted unit. But the politically exposed persons might be a very important politician and their family and their friends. So it's in that way.
You're suggesting that a dispensation similar to FICA should be applicable to politically exposed persons.
And then the exchanging of information. It's sad, actually. Our own legislation in South Africa makes it difficult to exchange information.
Exchange information between whom?
SAPS, SARS, etc. There are many limitations. So there should be these institutions sitting around and trying to find an easier way so that we can get alignment and we can cooperate. I mean, the irony is that in some respects we are compelled to share information with international institutions, but we can't do it inside South Africa.
Are you saying there are legislative provisions that prevent that?
Yes.
Are you talking about those provisions in the Act which prohibit the disclosure of taxpayer information?
Yes, but it includes that, but it's not only about that. All the other institutions also have restrictions. So all of it makes it very difficult to navigate through.
But you're not suggesting individual taxpayer information should form part of that recommendation of yours?
No.
Is there anything else you'd like to add?
I won't be long, maybe just one or two things. I don't think it has been mentioned, but we have recorded for quite long a pattern of attacks on SARS. The first dossier, intelligence dossier, started about 2003. And every year or so we've received another one, which gets sent to newspapers, which gets sent to politicians. And for most of the time, we've managed to defend ourselves against those accusations. And I must say most people, media, politicians, have behaved responsibly until towards the end. By the end, I mean, I think by 2013, I'm reminded by my colleagues that I had said already that, look, the storm is coming by the end of 2013. The signs were there. And SARS is not unique. This has happened to other institutions. So there is this pattern. And in our case, in SARS, it's tax delinquents, it's ex-employees, and quite a bit of rivalry from other state institutions. There is a matter, for example, that Barry would have mentioned yesterday, Mr. Barry Hall. I don't know whether he mentioned this perspective. When we intervened to save the DHA and the World Cup, that solution cost 40 million rands. And we used a solution that we already had. We had to tweak it and refine it and apply it in a new situation. And we saved the state many millions, many hundreds of millions of rands. But it actually led to the complaint, why is SARS now a technology company? We obviously upsetted some tenderpreneurs or some suppliers. It all led to the mounting problems that we experience. But we also experience where some of the tax delinquents, customs delinquents, take active steps to actually profile SARS people, to investigate SARS people. I mean, I have a report here in 2012 where we did a search and seizure, and in examining the computers, we found data about SARS people, and by the way, SAPS people. So the delinquents were investigating us and law enforcement. So we're in quite a difficult situation. I mean, we used to publish a weekly note, and I'm going to read and end at that. Just two paragraphs from the note.
When you say we as in SARS?
Yes, myself. 8th of August 2013. I'll quote the note. It says, in between our normal work, we've had to fend off opportunistic attacks on SARS from certain taxpayers and former employees. For the first time since the promulgation of the Tax Administration Act, we invoked Section 67(5) to defend ourselves in public against false accusations. This section was designed for such moments. It enables SARS to publicly rebut falsehoods that are peddled in order to confuse public opinion. The one claim that those who peddle these conspiracy theories never make is that their tax affairs are in order. We've also had several former employees who left South Africa, who left SARS under a cloud, come out claiming that they have files which they had released to the media unless we offered them their jobs back. Against these attacks, we hold steady and keep our focus on our work. If we keep doing the right things, we will deepen the trust that the South African public has in SARS. So we're in quite a permissive environment where individuals and groups of individuals push their self-interest to the maximum. And the state is not getting on top of it. Maybe the very last point, the dossiers. The dossiers remind me of the, what is said to be the Nigerian scam. Is it the 417? Is it? 419 scam. Okay. Apparently, the 419 scams, those notes are written in that way because it eliminates most people who will ask questions. And the only people who respond to it are the real gullible. And you have to read some of these dossiers, like dossier Spiderweb and so on. And it's a little industry, and it just keeps going on continuously. I think that was the general remarks I wanted to make. Thank you.
Thank you very much.
Thank you from my side, Mr. Pillay.
Is that?
We have one more witness. Can we take a 5-minute break?
Yes, certainly.
How's your little girl?
She says the doctor said he gave her medication and she's also...
That's how I was recruited.
Iya kan yang lebih juga masternya. Masternya. Ya.
In 2015. You served out until March 1915. What was your position within SARS?
That is correct. Firstly, good afternoon, Judge and your panel and Advocate Steinberg. Thank you for the opportunity to appear before you, and hopefully I can assist in some way with the work that you are tasked. I was a spokesperson for SARS, resigning on the dates that you alluded to, 19 February, and my last day of employment at SARS was 19 March 2015. Thank you.
So you were the spokesperson?
That is correct.
We're in possession of a letter that you wrote to the chairperson of the Standing Committee on Finance and the chairperson of the Joint Standing Committee on Intelligence. It's dated 24th March 2015. And So you wrote that letter really a few days after you left your office at SARS.
That is correct.
It's a useful letter for our purposes because it really quite extensively summarizes why you resigned. And, well, really, in your words, the reason for the letter, which you say at paragraph 2, you say you have reason to believe that the Commissioner of SARS, Mr. Tom Moyani, will be addressing these two standing committees in the coming days on the events that have recently occurred, and you want to put your version of the facts before these committees, which you say is a true version of the events, and you want to apprise them of what you say is the heart of the ongoing matters at SARS. And this is the letter where you capture that. Now, we have the letter, we'll look at it in some depth. I really just want to ask you to elaborate on certain aspects. You start by saying that during the latter part of 2014, you say, I was caused by the Commissioner to issue statements to media, and it became apparent to me at a later stage that such public statements contained false and incorrect information. Can you elaborate on that?
Thank you. I can recall at least 3 instances for the period October, November, and December 2014, where I had either to answer to media inquiries that SARS would receive, or I had to draft and issue a media statement on behalf of SARS. It started with the systematic withholding of information from me. And I contend it made it impossible for me to do my work effectively, and my working conditions became intolerable. Things were happening in the institution that found its way into the media and into the public space. I am the person to whom journalists come seeking clarity, seeking confirmation or denials, or seeking basic information about what was happening. And in those conditions, in 3 instances that I can recall, I had to construct public comment, issue it to a media institution. It was subsequently published, and because information was being withheld from me, by Mr. Moyane in particular, I effectively issued wrong or incorrect statements to the media. I can explain the first 2 instances if you want. The third instance I remember very clearly. It was on the 3rd of December 2014. I was called into the Commissioner's boardroom. I was briefed by him and the head of HR at the time. And this concerned the resignation of Mr. Barry Hoare as Chief Operating Officer. My apologies, it's not the 3rd of December, it's the 2nd of December 2014. SARS then issues a statement announcing the resignation. I was instructed to write it in a particular way, and it was approved by SARS. And basically, we say to the media, Mr. Hoare has a distinguished career. He's done wonderful work at SARS, and he has displayed instrumental leadership. And then the Commissioner is quoted. He thanks Mr. Hoare for his selfless commitment and diligence to SARS, and for his leadership as a member of the SARS management team, unquote. My issue with this statement was that it became apparent to me later, to me and other people in the institution, that despite telling the world that what a wonderful employee Mr. Hoare was, that they are leaving on good terms, parting ways, SARS was in effect working very hard to bring some kind of disciplinary proceedings against Mr. Hoare. I believe it was in the form of a grievance from a subordinate. I don't know if Mr. Hoare testified to that in appearing before you. But it clearly contradicted the image we tried to portray of the second most senior executive leaving and that everything was well. Everything was clearly not well.
Mr. Hoare did testify. He told us that after he'd resigned, SARS continued to pursue the matter, the grievance that was against him.
That is correct. And for me, it was puzzling at best, probably irrational at worst. Someone gives notice that is resigning. As the employer, you accept the resignation and you instruct the employee you must serve your month's notice period. And in that last period, you still want to actively push a process where you want to bring charges of some kind against the employee. That to me was a very early sign of the vindictiveness by the new SARS management against some of its most senior employees. And it was very concerning. And like other former colleagues who testified here before now, it was an indication of the climate of fear that was starting to develop within the institution.
Judge, I should have pointed out that there are two reasons I asked Mr. LACKEY this question. The one is that it goes to why he resigned ultimately. But the other is that one of our other terms of reference is whether any media statement issued by SARS or similar statement in any way brought SARS into disrepute. And I think this testimony might be relevant to that too.
Well, if you're going to expand to that, that's fine. I mean, we'll have to hear it at some stage. If it's convenient to hear it now, well, we might as well hear it now.
Yes. Are there other... Sorry, please go ahead.
Happy.
You're happy. Are there other examples you'd like to give us in that regard?
Yes, I would, if I may check my records.
Can I just ask one question, if you don't mind, before? To whom did you report at the time before Mr. Moyane was appointed? Where was your reporting line?
As spokesperson, I always reported to the SARS Commissioner. My office was on the same floor as that of the SARS Commissioner, specifically for that purpose. And then for daily administrative purposes, we would report to the company secretary.
Formulating communications to the outside world, etc.
That was
to
all
the SARS Commissioner.
SARS Commissioner, sir.
And then post Mr. Moyane coming?
That was part of the complications for me. That relationship started to break down to the extent that there was no regular interactions anymore. And this was at a time when the institution was in the headlines week after week, as I'm sure you know for that period, the last quarter of 2014 and the first quarter of 2015.
So you were going to give us other instances where you felt you were compromised in what you told the media.
Yes, thank you. I can refer to the media statement issued on 5 December 2014. That was a media statement drafted and created without me having sight of it before it was released. It was issued in the name of the SARS Commissioner, Mr. Tom Moyane. It was a statement to announce the resignation, or the suspension rather, of Mr. Ivan Pillay and Mr. Piet Richer. And the statement clearly uses as a basis for these suspensions the Sakonnet report and its findings. If I will be allowed to quote from it, the Commissioner said he sought legal advice on how to deal with Sakonnet's findings. Based on the findings and recommendations as set out below, in other words by Sakonnet, I have therefore decided to suspend the following two senior executives pending a disciplinary process, and the executives are listed as Mr. Ivan Pillay, Deputy Commissioner, Mr. Piet Richer, Group Executive, Strategic Planning and Risk. Then it delves into the findings of the Sakonnet panel and so on. As I've said, I had no input, sight or knowledge of this statement. It was issued And that's the first time I saw it. Now, going back to the earlier testimony of Mr. Pillay and the Labour Court proceedings, about 2 weeks after the statement is issued, the Labour Court finds Sakonnet made no adverse findings against Mr. Pillay, or any other third party for that matter. Yet, when this thing is issued beginning December to the media, Sakonnet is held as the reason why these people must be suspended, and suspended immediately. So this is clearly a distortion of fact if measured against Judge Person's judgment in the Labour Court of 18 or 19 December. And things like this made me very uncomfortable on the one hand in doing the work I was required to do, and very uncertain about my own role in the future within SARS. I can continue with two other examples, being mindful of time, Advocate. 4th February 2015. By this time, my duties as a spokesperson had been substantially diluted. I was told you will no longer speak on certain matters to the media on behalf of SARS, and other people will, specifically Mr. Luther Lebilo, who was a HR, he was an executive for employee relations in human resources at the time.
Which were the matters that you weren't allowed to speak about?
I wasn't. The explanation given to me was, Adrian, you cannot speak about employee issues to the media anymore. Effectively, it meant that any inquiry about these rogue unit allegations cannot be answered by me anymore. And then I was also told I would report to someone else, but that's another matter. 4 February 2015, Mr. Johan van Logrenberg resigns. We are then instructed, you will issue the statement. If I may quote from it, it says, Van Logrenberg resigned, and SARS hereby confirms that the parting of ways was amicable and agreed to be in the best interest of SARS. And then SARS wishes Mr. Van Logrenberg all the best in his future endeavors. SARS considers the matter fully and finally dealt with. This is for February 2015. To my knowledge, from this day to 15 May 2015, when case number 427/05/15 was opened by SARS, with Tomuyani being the complainant, SARS had never fully and finally closed the matters against Van Logrenberg. This is a blatant lie in writing that we are told to issue to the media. They never stopped KPMG or instructed KPMG on 4 February to say, stop the forensic investigation into the allegations of rogue unit. Stop the investigations into the conduct of Mr. Van Logrenberg. And sitting at that position, in this position as spokesperson at this time, I knew this was completely and patently false. That's where I'll end. After that, I left.
Sorry, second, may I ask?
Please, Professor.
When you were operating as communications officer, did SARS have a media policy? Was in the code? What did it say? Who issues statements? What should be their policy in doing so?
Thank you. There was a code and there was a policy. I have it somewhere here if I need to make it available. But it basically said that the commissioner of SARS and the SARS spokesperson are the only delegated people to speak publicly on behalf of the institution, and that the commissioner may apply his or her discretion to delegate any senior executive to particular speaking opportunities or media interviews in public.
That speaks to who issues the statements. Is there any policy on the integrity of statements, that the ethics of it, seeing you deal with vitally important taxpayer issues that affect the economy? Is there no code of conduct prescribing how SARS operates on that?
Sir, to my knowledge, the code or the regulation or the provisions were never that specific. We always worked with the understanding that before any public communication goes out, it has to have the explicit approval of the commissioner or someone acting in that position in the absence of the commissioner. Where matters, taxpayer information, sacrosanct, it's confidential in terms of the SARS legislation. We can never divulge information into the public domain or to the media unless a matter is before a court of law. So that was also clearly understood. And then thirdly, any public speaking opportunity, a meeting with stakeholders where the media would be in attendance, that was always cleared with the commissioner as to who goes, which senior person would go and speak, and what topic they would speak about, or what the content of that presentation or speech would be about. So in simple terms, the commissioner was the ultimate authority to sign off on such things, or a person delegating in that, or delegated to act in that position in the absence of the commissioner.
May I just ask you, Mr. LACKEY, you say you were the spokesman for SARS. Was that in your job description? Is that what you were employed for?
Correct, sir. That was my title. That was what my key performance indicators were. And I was officially on my job card, on my salary slip, my position was spokesperson for SARS.
Now, you've told us that as well, that under the policy, the commissioner could delegate that power, as it were, to other people to speak on behalf of him or of SARS.
That is correct, sir.
And you've mentioned that he had Mr. Lebilo speaking on his behalf at times.
Correct, sir.
Well, what's wrong with that? Is there anything wrong with it? Was he not entitled to delegate that function to Mr. Lebilo?
Yes, he was.
Can you tell me as well, you said, well, after this you resigned. Just explain a bit more. Why did you resign? What prompted you to resign?
I felt that my working conditions were becoming intolerable, basically because information was being kept from me on the one hand, and on the other hand, there was a very active, what I can call disinformation campaign, being driven in the media, and which manifested itself week after week from around 10 or 12 October 2014 throughout the rest of the year into 2015, where confidential internal SARS information, taxpayer information, is selectively leaked to the media, and the Sunday Times in particular. When I object to this in writing to the commissioner and say we have a problem here, it's difficult to do my work when it looks like our own colleagues are running this campaign. I raised those concerns in writing, there's no response, and no action taken. I put in writing, I warn about the reputation of the institution. I caution about the fact that employee information finds its way to this newspaper. At some point, we receive inquiries where journalists are in possession of all the investigators who work in a particular investigative unit and their ID numbers and cases they worked on, and it could put them very practically in the way of harm because they dealt with high-risk investigations. So I raised these things, there's no response. My relationship with Mr. Moyane deteriorated significantly throughout October and November, and it results in the instance I quoted from 5 December, the suspension of Pillay and Mr. Richa, where a statement is issued that would have far-reaching consequences for SARS. I know nothing about the suspensions. I haven't seen the Sakonnet report. No such information is being made available to us. And yet I'm called on to respond, to go answer calls from radio stations, go on radio, do interviews about a matter which I have no information on. that's where we ended in December. By January 2015, there were threats to charge me, allegations that I peddle information to the media by Muyane, and then the instruction from Mr. Jonas Makwakwa to say other people in the form of Mr. Lubilo will not speak publicly for SARS. That I would still draft public responses on whatever issues, but it must be, Luther will basically take over some of my functions. And by 19 February, in a climate of hostility and fear, which was completely strange to most of us who had worked at SARS under previous commissioners, by 19 Feb, I couldn't do my work effectively anymore. I was intimidated by the situation. Many senior people had resigned or served their notices of resignation, or others were suspended. And even when they won in court, in the case of Mr. Pillay, they were resuspended. And it was a very difficult place to work in the first quarter of 2015. A combination of those things informed my decision to resign.
Michael? Nothing more.
You've made reference to the statement of about the 5th of December 2014 that you are uncomfortable with relating to the suspension based on the Sakonnet report. Were you ever made aware that there had been a rebuttal by Mr. Pillay on the allegations that and on the report of the issues raised in the Sakonnet report?
Yes, I was fully aware. And that partly informed my decision to write to Parliament on the 24th of March 2015, because we helped Mr. Pillay with the management of his documents. I was aware of the team of lawyers that helped to draft his, firstly, submission to Sakonnet, and secondly, the critique after the report was given to him in November. And what I basically tried to explain to the two committees, there are these investigations, and when people make formal written submissions, and Mr. Pillay's submissions were extensive, Sakonnet doesn't deal with it at all. Everything Mr. Pillay testified about today, for example, the interaction between SARS, National Intelligence, and later the State Security Agency, the minutes of meetings, the correspondence between SARS, Police Crime Intelligence, correspondence between SARS, the Hawks about joint investigations, when all of the projects the units under his authority worked on, how they were constructed, the ministerial approval that was given in 2007 for the establishment of the National Research Group, that body of evidence was put before Sakonnet. And when reading his report, the Sakonnet panel doesn't deal with any of that. And I try to argue to the chairpersons of the committee, I can see injustices being done here in that the people affected by these investigations are not properly being heard, and submissions they make are not properly being regarded by investigations. So yes, to answer you, I was fully aware of Mr. Pillay's submissions to Sakonnet and his critique on the report.
But were you aware of Mr. Pillay's submission at the time of the statement being issued around his suspension based on the Sakonnet report, or did you get to be aware of that after that statement had been issued?
I was aware before, sir.
Now, there's also one instance we've heard of here relating to, you've just dealt with Mr. Hall's resignation and the statement that was issued in relation to his resignation. There was no disciplinary action against him, as I understand, that also was the submission of SARS in your CCMA matter against SARS. Am I correct?
That is correct, sir.
Now, were you still at SARS at the time when certain leaks of information landed in the public domain suggesting that Mr. Ho was subject to disciplinary action?
Yes, I do recall one such article.
Were there any steps taken to correct that information by SARS? Any active steps to clarify that there had actually been no disciplinary action against Mr. Ho?
No, sir, not to my knowledge.
Sorry, can I start one? As Advocate Steinberg has said, one of our terms of reference is the media issues in SARS. From your extensive experience, do you think that there's any regulatory compensation that should be applicable to the media implications of SARS? Should the incumbent who represents them, who makes them, have to have any particular qualifications? Should there be a code of conduct regarding media issues by SARS? Is there any regulation that you think, based on all your experience, that should attach to SARS's media communications?
So it is in the SARS code for employees, as far as I can remember. I can't remember now what it says and how developed or refined it is. So that's the best I can answer to that one, sir.
Well, on that, you mentioned you had the code with you. Do you have it here in this room?
Yes, I would.
Will you give it to Ms. Steinberg before you leave?
Absolutely. It's part of my CCMA bundle of documents, so as far as I'm concerned, it's in the public domain.
And perhaps we should turn to that. A lot of this is detail of what you've already covered. I'm not sure if there's anything else you want to pick up on before I go to another topic.
I'm comfortable to proceed.
Maybe just before you could proceed, if you allow me, Advocate Steinberg, you made the submission to the chairs of the Standing Committee on Finance as well as the Joint Standing Committee on Intelligence. Was there ever any response you received on that?
No formal written response, acknowledgement email to me, no. The chairperson of the Standing Committee on Finance, Mr. Yunus Karim, contacted me 2 or 3 times by telephone to convey to me that the study group of the ANC would look at the letter. That's the only reaction that I got. At some point later, I read in some of the media reports that the Finance Committee decided to refer the matter to the Joint Standing Committee on Intelligence, who would deal with it, and obviously their proceedings are in camera. I had never received any communication from that committee. And then sometime later, after I've sent it to the chairs, a copy of the letter found its way out into the public domain.
So you don't know whether this letter ever served before those committees that you sent it to?
The Finance Committee, and this is in the parliamentary minutes the Finance Committee didn't want to deal with the letter. So Dr. Dion George, who was a member of parliament for the DA at the time, obtained a copy. He wanted to table it in one of the meetings of the Standing Committee on Finance. The chairperson and perhaps some other members of the committee objected to that, and it was never dealt with or tabled. Mr. George then proceeded to publicize the letter, as far as I know, and that's how it found its way into the public domain. Sorry.
And then please carry on.
With your permission, And Mr. George, would he have received it by virtue of being a member of the committee, the standing committee, or did he find it in other ways, the copy?
His version through media interviews at the time was that he received it in his pigeonhole postbox in Parliament.
Now, it was leaked into the public domain, and this takes us to our next topic. Is that caused a bit of trouble for you, didn't it?
A little bit, to put it mildly, yes.
Tell us about that.
In response to the letter being publicized and reported on by the media, the first reaction by SARS was a letter of demand from the attorneys Mashiane, Mudli, Munama. They wanted me to withdraw the letter or the submission to Parliament, and I instructed me to apologize to Mr. Tom Mashiane as Commissioner. It gave me a period of, I think, 7 days, and I refused. And then the sheriff ended up at my house with a summons. They were basically suing me for defamation. For SARS, the institution, on the one hand, for 10 million rand. And then Mr. Moyane, as the individual or the commissioner, on the other hand, for 2 million rand. So combined summons was served on me for 12 million rand defamation. And that happened around May or June 2015. During that period also, Mr. Labilo would go on radio and indicate that SARS started, SARS opened a criminal case against me for the leaking of confidential SARS and taxpayer information, basically contravening, I think, Section 69 of the Tax Administration Act.
And then what has been the fate of the defamation action?
We managed to, by the end of last year, struck off the 10 million part.
In other words, SARS's claim was
Correct.
struck off, presumably because you can't defame an institution. But Mr. Moyane's claim is live. Are you still facing
Correct.
that?
As far as I know, it's live, and that's a 2 million part, which I'm sure you will have to decide how to proceed now. And concerningly for me, he's part of the litigation. That, I mean, they use the same set of lawyers, which is SARS attorneys and counsel for SARS to litigate against me, as he says in the summons, in his personal capacity. I don't know if that's correct or proper in law or allowed for, but that is what happened.
The criminal charges, where are they up to?
I've never received any. The only indication of criminal charges which surprised me was on 9 June 2015, an interview Mr. Labilo did on Radio 702 with John Robbie, where he speaks about the defamation claim, and then he says to the radio station that a criminal case has also been opened against me, I think at the Hawks. I don't know, I've never received any notification from any law enforcement that that matter is live.
Sorry. Okay. I just want to understand, how has this affected your prospect of getting employment elsewhere, and how has it affected your family?
Sure. With respect, Advocate, the family part, if I answer that in full, I'm sure I'll end up in tears, which I want to avoid. Because I think, like many other people who had until now appear before you, it was traumatic and it was stressful. And I'll leave it at that, the family part. The prospects of employment for 2015, we basically felt, and when I say we, Mr. Pillay, Mr. van Logrenberg, Mr. Yolisa Pique, with whom I had regular contact, by by May 2015 were all out of SARS, either dismissed or resigned. And we basically felt we became unemployable. I approached about 4 or 5 large corporates, financial services companies and banks, amongst others. I went through formal processes with at least 2 of them. And then in the end, the results come back to say, look, as long as this SARS cloud hangs over your head, you are perceived to be a risk to our institution and we can't employ you. And people would say, we know who you are, we know what you did the right thing, we support you, but we can't employ you. Effectively, that was the message. And 2015 was a difficult, lonely place for us. By 2016, our group managed to find some contract employment, and we were able to sustain ourselves again in a better way. But more for my colleagues and for me, I think this rogue unit shadow will forever follow them, whether it has merit or not, and I strongly argue it was concocted nonsense. But wherever they go, whenever any journalist writes about Mr. Ivan Pillay, Johan van Logrenberg, it will be about, reference will be made to an alleged rogue unit. I think their reputations, more than mine, have been harmed. I think people still carry the scars, and hopefully someday a better sense of justice will prevail for them. People like Mr. Pillay, in my view, deserve to be back in an institution like this, or any other state institution where we need help, we need capable people with his experience in leadership positions. And at the moment, it can't happen. So I've been affected, but I think other people have been affected far worse.
And the cloud that the prospective employers have raised in relation to you, does it relate to the criminal charges that were said to have been laid against you, or is it the civil suit?
The latter, sir. Ivan and I went to see, I'll keep it vague and open, a former cabinet minister. Sometime during 2015 or 16, to say, do you know of any options or people we can talk to for employment or for work? And this former cabinet minister told us, no one wants to invite problems with SARS into their backyard, and at the moment, that stigma is attached to both of you. And that is pretty much how we felt. And in my case, to come back to your question, it would be the civil litigation that received most prominence in the media at that time.
Okay. Thank you very much, Mr. LACKEY. Thank you very much for coming.
Thank you.
Is that the end of the evidence for today? I just want to say something, and I've said it a number of times, and I will say it and keep saying it. We invite any submissions from the public or anyone else. None of the people who have given evidence here have been compelled to do so. All of them have been invited to do so, and we've heard their evidence. We will weigh their evidence when we've heard all the evidence. Not at this stage. We will weigh it when we've heard what anyone wants to say. So if anyone wishes to make submissions, give us facts, they are invited to do so, specifically invited to do so. Thank you.
Thank you.
Tomorrow morning, Judge.
We'll commence again at 9:30 tomorrow morning.
Is here.
Is it safe to do so?
No, not here. Locked up.
Oh, okay. Sorry.